right, this is cause number 1830854, and sir, you're Juan Sanchez?
Yes.
And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena duces tecum.
Here's a polished rewrite of your legal insight. A subpoena duces tecum is meant to force someone to produce documents at a scheduled hearing. In this case, though, there was no hearing set yet. The judge's response: creative attempt, but that's not how this works. If you want, I can also make an even punchier social media ready version.
Is the proper way to try to get the information. Duces tecum is an order to get somebody to bring something to a set hearing. So we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena duces tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests, and then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results, testing, money owed, all of those types of things I think are probably discoverable and something that Mr. Franklin needs.
Here's a tightened, clear rewrite of that. Pause and take note. They're trying to subpoena the entire probation file for an out-of-court arrest that barely matters to the motion at hand. It's like demanding the whole cake when all you really need is a single slice. Strategic move or blatant overreach, you decide. If you want, I can also make a version that leans more dramatic and courtroom ready for storytelling.
I just don't think this was the...
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance for record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations.
Well, let him finish, yes.
He did subpoena Morgan County records from probation down there, came in today for this. I have no problem getting him on that stuff. A lot of it's not in my possession. County office reports and things like that. I don't have if we were here what those allegations were. And again, I think he's not entitled to have it.
Sure. So,
directly to those agencies. And Mr. Franklin did make a substantial as to the onset of his involvement, which was early May.
right.
I don't have anything really responsive to that
Okay.
at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. So that needs to take place as quickly as possible. Let me look at the motion itself, because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including...
Here's a punchier courtroom storytelling version. This is the moment the defense grabs the spotlight. The lawyer emphasizes the client's nearly 6 years of clean probation, framing it as mitigating evidence. Suddenly, the story shifts. Not just about past missteps, it's about the progress that can't be ignored. I can also craft a couple more high-drama variants that lean into tension and storytelling if you want.
his payments, his everything else. As part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requested to stay on with probation, or if the court decides that he goes off of probation, and perhaps mitigating
I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence.
Yes,
so that's not the way we're going to do
The
it.
ducis tecum was set for the day that was initially set for a hearing, and it did specify that day for the hearing. We ended up moving the hearing dates because of
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together today.
Yeah.
To turn over.
I mean,
Unless
yeah.
there was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. LeBeau, is there anything you have
If there's,
the court aware of?
Your Honor, just with the clarification, like our departmental chronological should include anything that pertains to the case, auto-generated appointments, reminders, office visits, that's nothing to be entered into. But those are probation office as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed with the exception of
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion. And I would also note that the chronological rules.
well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out though, I think whatever Mr. Nichols, y'all get together, obviously offense report, if y'all have the offense report and you don't even have it, then you need to get, I mean,
Right.
that's great. Everybody can get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be.
Here's a tightened, more readable version of that. The judge is clearly alarmed. The defense even had to file a motion to compel under Rule 39.14, the rule that guarantees defendants access to evidence. Having to fight that hard just to get what's constitutionally theirs, that's a major red flag. I can also make a punchier courtroom drama version if you wanted to hit harder.
That's what I'm thinking about, but it's not really attorney's notes, and so I don't know that that would be
I
an
would object
issue.
to that, Your Honor, on the grounds that it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
That's what I just said. You seem very frustrated, and I'm not sure why. I don't know.
I'm confused why there's pushback at all in any request for a 3914 discovery when it's constitutionally allowed to access this file. It should just be produced by probation without a file. We got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
that is alarming to me that we would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases, and so if there is something, if you'll sit around and watch today how everybody gets along. Hold on.
Here's a polished, punchy rewrite of that. And boom, courtroom etiquette 101. Even when the judge agrees with your point, showing up hot and combative can backfire. This judge basically says, cool it, stick to protocol, and let's reach the finish line without the theatrics. I can also make an even snappier social media style version if you wanted to pop.
And the last thing you want to do is talk over me. So I'm sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want this stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to individual attorneys in cases because I think